se, so I'm not going to linger on those, but I think it's important to give credit where credit's due. That will be the end of the credit giving. Okay, so I'm not an anti-regulatory person. If you identify as that, I'd ask you if you're also an anti-safe drugs and food person, also an anti-clean air and clean water person. I think most of us understand that regulations can be in the social interest, in the public interest. The question, of course, is where to draw the line. But I take this administration at its word that what it wants is to accomplish deregulation, so I'll be evaluating it on those terms. And so Susan teed up for us the fact that we've got the 10-for-1 executive order that's accompanied with a regulatory budget. This is very much like what we had in the first Trump term. Now, neither of those tools alters the fundamental truth that the president cannot lawfully, meaningfully deregulate on his own. Any deregulatory strategy that does not involve Congress is marginal at best. So if your deregulatory strategy only involves executive actions, you have conceded from the jump that you do not have a very ambitious approach, right? Because Congress is the entity that has enacted the statutes upon which agencies are obliged to regulate, right? And there's only so much the president can do to dial those up or dial those down. So I can tell if someone is serious about deregulation if they are involving the idea of legislative change, and so far, although I think we'll hear from Bill that there may be some instances where this is happening, you aren't seeing the kind of legislative engagement that we would need to see a large-scale deregulatory effort. Instead, this appears to be the president trying to go it alone again. The evidence from the first term is that Trump was effective at stopping the flow of new regulations, at least until he decided that he really wanted to do some regulations. But at least at the beginning, he effectively turned the spigot off. We refer to this as the regulatory flow. Where the Trump administration in the first term did not succeed at all is in shrinking the corpus of regulations on the books. So we have a few ways of measuring regulation. None of them are very satisfying, I'll be honest with you. But one of them is to look at the complexity or the page count of the Code of Federal Regulations. The Code of Federal Regulations at the end of the Trump administration was no smaller than it had been when he entered office. So that is in direct opposition to the many, many talking points, right, claiming that one of Trump's 3 accomplishments was on deregulation. I think we can say that he effectively slowed the imposition of new regulations, but when it comes to getting into that stock of that corpus of existing regulations, almost no activity there. And that was also partly, not just about the executive orders, but it was also the general regulatory antipathy of the top officials in the first Trump term. Okay, so what's new here in the second term? Because so far, what we've introduced is something that looks a lot like term 1, and I've told you that if you only had those, then you shouldn't be expecting much actual deregulation. Okay, so what's new is this DOGE, the DOGE of it all, okay? So let's see, what are they up to? Okay, I've read in the paper that they are looking to use some tech tools like AI-informed tools, whatever that means, to crawl through the Code of Federal Regulations and identify some candidates for deregulation. Okay, interesting, right? Who knows what could be on that list? Those are gonna have to be evaluated by people with the appropriate subject matter expertise to figure out which ones of these are actually viable, which ones are required by statute. For example, where does the executive actually have discretion to make changes to the regulations that these tools come up with. And then to follow through on any of these ideas, to write explanations for why the government is pulling down these regulations, is making a regulatory change, requires the expression of reasons. Reason giving is a central pillar of the Administrative Procedure Act and how executive branch agencies go about justifying regulatory changes. And that's not just the administrative procedure, it's decades and decades of jurisprudence that has elaborated on the court's expectations for what agencies need to demonstrate when they are making changes to their regulations. Now, I would say laying off, demoralizing, and immiserating the civil servants who work in the federal agencies reduces the capacity to write these reasoned explanations. These are the people who understand how to explain what the government is doing, and so we're dialing the capacity down by taking those actions. Perhaps AI can save us though, right? Perhaps AI can just do the drafting even. Let's just plug it in to a generative AI, say give some reasons for why we're changing the regulation, and that's great. You don't need staff for that, right? We know generative AI can produce reams of documentation, so if all we need is reams of documentation, then maybe this is the solution, and who better than Doge to help us realize this concept? Well, I recently wrote a paper called Ghostwriting the Government, which argues that when the government has a fundamental duty to reason, that duty cannot be outsourced. And when you outsource the writing, I don't know if we have any writers in the room. Do we have any writers in the room? Again, it's such a quiet room. I think some of you probably do some writing for your work. If you're anything like me, the writing is the thinking. The writing is where you refine your ideas, where you test your premises, right? Where you argue with yourself, maybe with your co-authors. The writing is the thing. The writing is the reasoning. So if the government just hands its regulatory preamble drafting to machines and then tries to publish them as its own reasoning, I argue in my paper that that falls short of the government's duty to do its own work. So we may well see some preambles that look to be on their face, and perhaps even diagnostically, we can discern that parts or substantial chunks of them are being written by generative AI, and I would argue that that is unlawful. Okay, so to recap, the deregulatory policy of Trump's second term is more of the same. Deregulation claimed as a success, but it was smoke and mirrors. It was talking points and inflated accounting gimmicks like the ones Susan described, although she didn't call it an inflating accounting gimmick, basically designed to give the president things to brag about without actually delivering substantive deregulatory change. Doge has underdelivered on its deregulatory goals, and tech cannot do the reasoning that agencies must do to justify regulatory changes under the law. In short, while there will be plenty of talking points claiming high achievement towards deregulatory goals, when you look at the details, I think you'll agree with me that in the immortal words of Shania Twain, that don't impress me much.
Thanks. Thanks, Bridget. By the way, that's Doge calling. You're in some serious trouble. And next we'll hear from Bill.
You will notice, no doubt, at some point that I am the one person on this panel who's not a professor, and so I will not be nearly as charming or as engaging or caring what you do in the audience. So I'm going to provide a little bit of perspective from a particular industry standpoint as to where things stand now with what the Trump administration is doing on the regulatory front, but that requires a little bit of backstory. During the Biden administration, we had not yet seen a great collapse of a pretty high-profile individual and his company, and so the Biden administration was pretty open to the idea of blockchains and cryptocurrencies, and they put out a number of papers and executive orders asking for research and industry feedback. FSOC, Treasury, SEC, DOJ all sought input from everyone, both in traditional finance and crypto and other sectors. The results were sort of a mixed bag. They seemed pretty educated about the technology, what it was currently used for, what it may one day be used for. When the market went south and some big companies that were not regulated enough blew up, a lot of people were politically embarrassed, and the regulatory winds shifted remarkably. Gary Gensler was applauded when he was sworn in as SEC chairman, in part because he taught a course at MIT about blockchain. I was one of the lone lawyers in space that said, like Lee Corso at Ohio State University, not so fast. Let's see what he does. This is the guy behind A lot of regulation post-financial crisis. What happened was prudential regulators and the market regulators, the powers that be, decided this industry needed to be kept separate, isolated, and if we can do it efficiently and quietly, we want to smother it to death in this country. And it can exist elsewhere in the world, it just can't exist here. And we're not merits regulators, but we need to kill it. The first thing the Trump administration did when it came in, to take a slight step back from that, I think Trump started to realize last summer, about a year ago, that this was actually a political issue. He stood before roughly 25 to 30,000 people in Nashville at a convention, and for the first time on the trail, he said, on day one, I'm going to fire Gary Gensler, and that is not, I'm going to fire the current chairman of the SEC is not something you normally hear a presidential candidate say. It got the largest applause that Trump had received probably that entire summer, and you can see in his head him putting two and two together, being like, okay, so this is an issue. And so he said, I'll say it again. And he said it again, got even louder applause, and he's like, whoa. And you could see, okay, he's going to be a Bitcoin guy now. First thing he did, even before I think the transition was over, was announce that he was hiring a crypto/AI, but mostly crypto, frankly, czar. Picked David Sachs, who's famous, you should know who he is, to play that role. Picked a former congressional candidate, Bo Hines, to be an executive director. The idea is that they were going to quarterback from the White House what the policy was going to be on blockchain across the executive branch and beyond in the new administration. We were hoping, a lot of people were hoping day one. I said, it's okay, guys, it can be week one, it can be week two, it's fine. We got an executive order basically setting out what the White House's playbook for regulating digital assets was going to be. First, they were going to have a presidential working group chaired by Sachs. On it would be all the relevant secretaries from Treasury. You'd have independent agencies on there. You'd have DOJ on there, Commerce. And everybody was asked to go out and find the regulations that are, and guidance and rules that are problems, find out what needs to be done in order to set aside what the Biden administration had been doing, which was such a problem, and put in something productive in its place. So what was the Biden administration doing that needed to be fixed first? So job one was undo the damage, and then job two, it wasn't just deregulate and leave a vacuum, because the vacuum was essentially the problem. It was to put something else into place. So what was the Biden administration doing that needed to be fixed? First was what has been festively called Choke Point 2.0, piggybacking on the famous Obama choke point affair at the end of his presidency. Choke Point 2.0 is basically taking anything crypto and separating it whole hog from traditional finance. That included our founder and CEO being debanked. That included us, after being a commercial client of one of the major Wall Street banks for 7 years, us finally getting a phone call saying, sorry, it's just too much. We have to offboard you. I'm really, we love having you as a client. We just can't have you as a client anymore. This came in September of 2024. What happens literally the Monday after the election? Hey, how's it going? Hope everything's all right. Would you guys like to go to a Knicks game or something? We want to start talking again. Choke Point 2.0, and FOIA has been very helpful in finding sort of the paper trail of essentially inside memos directing people at banks to offboard crypto companies and their founders, debank them, saying, we can't do your business. You've seen a number of letters and other guidance materials coming out from the prudential regulators saying, like, that is over. You can bank these people, you can give them checking accounts. Another thing that we've seen is at DOJ, a change in approach from a law enforcement perspective. The Deputy Attorney General released a memo saying no more regulation by prosecution. There have been a number of cases where platforms, not the bad guys who misuse the platforms, have been targeted for prosecution under sometimes very inventive theories of money transmission and sanctions violations. Notice the concept of facilitation is completely wide open, and so anybody in this room could be prosecuted at any moment for probably facilitating a sanctions violation, given how nebulous that concept is. But essentially it said two things. One, we're going to stop essentially regulating the space, saying what's in and out by prosecuting people and letting you all see what we're going after. And then two, we're going to get rid of the National Crypto Enforcement Task Force. To the great dismay of everybody who in the media who covers this sort of thing, there was a lot of pearl clutching that fraud was now legal. I hate to break it to you and burst their bubble. No, it's not. All the people who used to work on the task force now work at CSIPs or in the front office of the criminal division. They're all prosecuting the same bad guys in the same cases. They're just not going after platforms. Another thing the White House did was wholeheartedly support and whip votes for a Congressional Review Act repeal of a very hastily put through IRS rule that required software developers to change their software to report to the IRS transactions that users of that software were engaged in on their own that might have a gain or loss associated with it, essentially not just requiring the standard 1099 reporting from someone who's actual and intermediary broker, but saying if you produce software which allows someone to do it on their own, you are required by virtue of developing that software, you're required to do that on your own. Senator Cruz and a congressman who I apologize for forgetting his name, they pushed it forward as an initial initiative in the Congress, and the White House gave it its full support, and it was the first crypto-related bill that President Trump signed. So job number one, undo, sort of get rid of all the bad stuff. Job two, which we're just starting on, is put in a regulatory apparatus which actually mitigates risks while not being careless with the cost of the regulation, sacrificing innovation at every stop in order to put more controls on the system. The greatest example of this is the SEC's Crypto Task Force. We got off to such a blazing start in part because Commissioner Peirce and Commissioner Ueda have been such vocal opponents of a regulation by enforcement mindset at the SEC. And so I know for a fact they talk to the White House weekly about what their agenda is and how they're pursuing it, but that task force has been put together to try to organize the SEC to get rid of those rules and prohibitions that from the prior administration and put in place not only a rulemaking construct but a guidance construct to help put rules in place that actually protect the market while preserving innovative forces. The Presidential Working Group is going to be coming out with a report very soon with basically an action item list of rules to put into place, things that need to be fixed. We should expect that soon. They're also working very closely with Congress. David Sachs went up to Capitol Hill and stood. It helps that they're all members of the same party, obviously, but stood with the chairman of the Senate Banking Committee, Senate Agriculture Committee, and then the chairman of the Senate House Financial Services Committee, and then the House Ag Committee. They all stood on stage talking about how digital asset legislation, both on stablecoins and on market structure, was a congressional priority and an administration priority. So the White House is working hand in glove and going to be leveraging its influence, especially with the House, on getting legislation across, which actually puts in place rules which work both for the ecosystem and for the public, which is something the last administration absolutely refused to do, and in fact, certain agencies stood starkly athwart of. So we came out of the gate very early because the ecosystem has been thinking about ways to move a regulatory agenda forward so we can catch up to places overseas that have a better approach to this. It's refreshing that the administration is so vigorously and enthusiastically supported this, but the way they're doing it is putting very knowledgeable, smart, hardworking people into positions that can actually work on policy, and then looking at Congress as being a key centerpiece of a new regulatory agenda in this space. That's it.
Thanks, Bill. Thanks, Bill. Bill, at the very beginning, where you started by pointing out you're the only non-professor on the panel, it reminded me of decades ago when Daniel Patrick Moynihan was running against Jim Buckley for the Senate. And Buckley kept referring to him as Professor Moynihan, and Moynihan said, "Oh, the mudslinging has really begun now." All right, Professor Pierce.
Oh my God. I got to follow, I got to admit I'm a professor. Okay, let me set aside, to begin with, two types of rules. First, rules issued by the Biden administration. I think there was a lot of regulatory overreach during the Biden administration, and a whole lot of those rules either already have been rejected by the courts or are still in the review process, and I think they're not likely to fare very well. So I think there's a good chance that very little will survive from the Biden regulatory actions. The other type of rule I'd set aside is anything having to do with cryptocurrency. I can spell the word, I think, but that's the extent of my knowledge. I know I really know nothing about that area at all. But what I want to focus on is the claim that is made in speeches, at least all the time, that he's actually going to deregulate by eliminating longstanding rules. That's not going to happen. There's no chance in hell that's going to happen. So here's why. I mean, he's done some things that are likely to cut back on the time and resources required to try to repeal a rule. The most effective of those was actually not an executive order, but a decision of the Secretary of Health and Human Services withdrawing the waiver of the exemption from notice and comment rulemaking applicable to public lands, government benefits, grants, and contracts. That's a pretty big deal, and that certainly will cut back on the amount of time required to try to repeal rules that fall under any of those subject matters. The other thing he's done, as Susan mentioned, is he's issued a bunch of executive orders where he says, well, you've got good cause to get rid of notice and comment rulemaking in the following categories of cases because I say so. That ain't going to cut it. The courts are very, very stingy in upholding agency claims of good cause to avoid notice and comment. They may do so in a case or two, but what I'd recommend, the one that is my favorite, of course, Susan already alluded to, I think the famous shower executive order where I hate these damn restrictions on the amount of water you can get out of your shower. So tell them that you got good cause to repeal this rule because the president told you to. Well, that ain't going to cut it. I recommend that he does what I do, which is take the damn thing off and hope the FBI doesn't come and eventually, discover you've violated federal law and to, live with it, sport. He's going to enjoy some limited success in terms of getting rid of the notice and comment requirement for repeal of some types of rules. Not very many, but some. But then that gets you to the big stumbling block. There's an absolute prohibition, judicially enforced prohibition, ban on inadequately supported changes in position. And going from, yes, we're going to regulate this, to no, we're not going to regulate this, is a change in position, okay? And that doctrine has been around for about a century now. It's never been particularly controversial. It was most recently invoked in a unanimous opinion written by Justice Alito in the White Lion case, that notorious leftist judge. There's just no way in hell he's going to be able to overcome that with anything like, President told me to do it, so I'm doing it. How do you do that? You need data. You need data and analysis, and maybe AI can provide some of the analysis. It can't provide the data. And the data, unfortunately, is hard to come by. So all significant rules, every significant rule that's been issued by an executive branch agency since 1981 has been the subject of cost-benefit analysis. And the average cost-benefit analysis on every one of those rules, on every one of them, the estimate was that the benefits exceeded the cost, and the average was by a margin of 5 to 1 or 6 to 1, somewhere in that range. And a high proportion of those rules were then upheld by courts. So I really pity the poor government lawyer who's told, I want you to go to this court, and I want you to tell him, the agency I represent is so utterly incompetent that they got all the estimation wrong by so much that actually the costs exceed the benefits instead of being 6 times, the benefits being 6 times. And here's the data to support that. Yeah, tell me where, AI is not going to find that data. It's not out there, okay? And then, by the way, Your Honor, you also blew it when you upheld this. Your court upheld this 10 years ago. So, I mean, that's not going to work. And so they're going to have the same level of success that they had in the last administration, which is virtually none in terms of getting rid of any of the longstanding rules. Now, it's really useful to compare what Ronald Reagan accomplished by way of deregulation with what Donald Trump accomplished in his first term and what he's likely to accomplish in this term. What Ronald Reagan accomplished with roaring success and tremendous benefits to the economy was he worked on a bipartisan basis with Congress to get the repeal of statutes that imposed horrible, counterproductive, economically disastrous economic regulatory regimes on railroads, trucking, oil and petroleum products, natural gas, and airlines. And that really helped the performance of the economy tremendously. That was all done on a bipartisan basis through statutory enactment process. Okay? On those rare occasions when Ronald Reagan attempted to do what Donald Trump says he's going to do and just unilaterally repeal regulations, well, he made history, but he made history by creating the biggest obstacle to deregulation that is out there in all the cases. So what he did was he wanted to make good on a campaign promise he'd made in a speech to the UAW in Detroit, that he would repeal, or have NHTSA repeal, the rule that required all cars sold in the United States to have either automatic seat belts or airbags. And what that elicited was a 9-justice unanimous opinion saying you cannot repeal any rule or amend any rule except by going through the same laborious process that you have to go through to issue a rule, and then at the end of that process, your rule is going to be subjected to what's referred to in the trade as the hard-look version of arbitrary and capricious review, where you must engage in reasoned decision-making and you must provide data and analysis to support your repeal. That's not going to happen. And it might happen in 1 or 2 cases, but as Susan pointed out, for it to happen, you've got to have staffing. And there's not much staffing left. My daughter's 50. My daughter's been with a major federal agency for years now, and what she tells me on a daily basis is, nobody's doing nothing because we can't figure out what the hell we're supposed to do. We don't know who's still an employee. We don't know what the mission is. We don't know what the new organization is. We don't know. In her agency, she's on her 4th boss in 3 months, and so they're just trying to figure out what the hell are we supposed to do now. Well, what they should be doing, if there actually are rules, I'm sure there are a handful of rules out there where you could get the data showing that the estimates were wrong and that in fact the costs have been much higher than were estimated and the benefits have been lower than estimated. And then get that process going but that requires really hard work by a whole bunch of people who know what they're doing and know where they're going to find the data and how to engage in the analysis. And we're losing those people every day, and the ones who are left are so demoralized they don't know what the hell to do.
Great, thanks, Dick.
Otherwise, it's a nice day.
So
I'm going back to my uncontrolled shower after this, feeling better.
there's a lot of very smart folks in the room, and I want to make maximum time for questions. So we'll go to questions in just a moment. But before that, let me just make one observation and then just pose 2 questions of my own. Here's the observation. I think Bill's presentation it reminds me of one of the most interesting issues in administration right now. It's the problem of the ability of an administration to rule without rules, right? We saw in the last administration, especially around crypto, but in some other areas, the ways in which an agency can really assert authority and impose its will on a regulated industry or regulated parties, not by creating a whole new stack of regulations, but by operating in lieu of regulations, or even by repealing a lot of regulations and policies, and then leveraging the uncertainty that creates. Surely we'll see that in the current administration too. I think it's now a permanent feature of administration, and administrative law just isn't well geared for that. And I thought that crypto was an interesting test case for that. That's just my observation. Here's my 2 questions. I'll just pose them both, and the panelists can jump in on either of them, or they could go on and talk about whatever they'd like to talk about. And then we'll as they're answering, folks can line up and we'll go to questions. Here's my 2 questions. Executive orders, they come and they go, now more quickly than ever. They've always been around, but now there's just blizzards of EOs constantly, and especially in this administration, but also in the last few. If EOs are now sort of the most publicly visible version of lawmaking in the country, doesn't their malleability and just their temporariness, doesn't that really undermine, does that risk undermining the public's understanding of the rule of law, if the laws that we're now most familiar with are the ones that are most easily made and unmade? And the second question is this: the rise of governance by EOs, I think it's not a coincidence that it's coincided with the rise of just constant litigation around administrations, right? Each new executive order is signed and immediately there's a lawsuit. It draws the courts more quickly than ever into policy debates and political debates. And so isn't the rise of EOs contributing to a politicization of the courts? Those are my 2 questions, and maybe we'll just go down the line. Susan?
I might focus on the first one, and I think it does. I mean, the idea that an executive orders change every 4 years, it does undermine stability, and I'll use that to pivot to something that I wanted to add. Dick and I were in a meeting yesterday with a group of trade associations, and it was very interesting. I was a little bit surprised by their general sentiment. They were supportive of DOGE, their members, supportive of DOGE, happy about draining the swamp, no sympathy for the federal bureaucrats that are getting fired, and deregulation is a good thing, but not the chaos. So they actually were all very unhappy with what's going on, and I think it relates to that uncertainty point. So the National Federation of Independent Businesses does a survey every month, their optimism index, and the optimism, I think, was shot up to an all-time high in December. So after the election, optimism shot up high. It is now below average, their most recent one. It may even be towards the bottom. And the opposite direction, uncertainty has gone. The uncertainty index is now the 2nd highest that it's been, or was in February. So I think that uncertainty is a very important point. The reason that we need the rule of law, and as much as we don't like the tedious practices of issuing and deregulating, doing it through the steps that Dick has talked about are important.
Yeah, I'll just add on that point, it's striking that when you read the Federalist, after we get past Federalist 70 on the need for energy in the executive, Hamilton's primary concern is the need for energetic but steady administration, and he refers over and over again to the risk of think what he called mutable, the ruinous and disgraceful mutability of laws that he worried would come with too much change from one administration to the next.
I'll add one more thing, just a friendly amendment to Dick talking about the Reagan administration, and that was serious deregulation. And it was across all branches, but it was also very bipartisan and actually Jimmy Carter does not get enough credit for that because a lot of that started in the Carter administration.
If I had $1 for every time I heard Jimmy Carter praised at a Federalist Society committee. Next, Bill.
So my understanding, or when someone says the public, I don't think about anybody in this room. I think of people who don't necessarily understand what federalism is, who makes the laws. So to the extent the law sort of emanates from the Capitol building or it emanates from the president's desk, I don't think they know or care or even can tell. And because, they have real lives, they have stuff they need to care about. I do think what it does is it gives Congress a permission structure to avoid doing their job. Because if there's a political imperative to handle some such problem and the president stands at his desk and shows a signed executive order, I think the congressman or senator who would be put in an otherwise awkward position can just sort of point at that and be like, can I go now? And I think that's the problem. I do have some question as to how pervasive a problem this is or whether it's just a marginal issue. In the era of Eisenhower and Reagan, there was bipartisan agreement on a variety of changes or deregulation efforts because they were things that people could agree on. It seems a lot of what each side is doing from a regulatory standpoint is using the bureaucratic process to try to capture policy that they can't get otherwise through political means. And so it's really marginal issues where this is happening. They're going to be important issues for very particular constituencies, but they're marginal issues. Stablecoin legislation, and going back to the weird crypto world, it's probably going to get done on Capitol Hill because there's like enough bipartisan support of it. If there wasn't, so when there's bipartisan support, something is a significant problem and everybody can agree, okay, there's something to be done about it, you can go back to the normal process. It's on those issues where the only way we win is if we do this while nobody can stop us. And we'll deal with the consequences later. So if it's only the marginal issues where we're really disagreeing, maybe things aren't so bad. Hey, there's your sunny side of things.
And Dick?
Well, my answer to most questions is yes and yes. I'm very, very concerned about flip-flopping, and that's what we're seeing is just massive flip-flopping every 4 years. It has horrible effects on society in many, many ways. One of the most obvious is it massively discourages long-term investment. Who in the world would make a long-term investment expecting to get a good return over a 20-year period when you know that every 4 years everything's going to turn around? Well, of course, it never dawned on me that we could have in a single administration a situation where you can't make any investments at all because you say, well, the tariff's 120% today, might be 200% tomorrow, might be zero tomorrow. I don't know, it could be anything. That's madness. That you cannot run an economy that way. That is simply impossible, okay? I don't like the flip-flopping by executive order every time there's an election, but what we've got now is even worse than that.
All right, let's go to audience questions. Here's what we'll do. First of all, as always, please ask a question. And please point out who you'd like, which of the panelists to answer it first. Maybe we'll give 2 panelists a shot at each question. And we'll go back and forth between the microphones. Start here.
I wanted to talk about the dishwasher rule, and this will be directed to Suzanne and Dick. The rule that actually got issued was an interpretive rule that, at least under the APA, says isn't applicable to notice and comment. So I don't understand what the problem with that. And the other thing I just want to think going forward on deregulatory, One thing the president might do going forward is issue executive orders ordering the exercise of prosecutorial discretion not to prosecute people for something, and then there is no rule under the APA for anyone to challenge as arbitrary, capricious, or anything like that. It just, they implement the president's executive order directly. And while you would still be able to challenge that potentially under an injunctive relief, that would potentially only apply to the parties. So what are your thoughts about that as different ways that the administration might go forward to deregulate?
That was 2 questions, but I'll allow it this time. Real quick, Susan and Dick.
Yeah, I'm not as sure about the dishwasher rule. So I was talking about the shower rule, which I think was implemented through notice and comment rulemaking. And as you know, Devin, probably better than most people, under that act, there's a, what is it, no fallback or no something. So backsliding, yeah, no backsliding. So it's hard for me to understand that. I mean, I'm also very supportive of getting dishwashers to work again, but I don't know how that one was done. So I'll refer to the lawyer. I'll defer to things to the lawyer.
So generally, interpretive rules can be eliminated with a stroke of a pen. So that's, I don't think the shower rule is an interpretive rule. I think it's a legislative rule. But any interpretive rule can be changed with a stroke of a pen. As to your second question, my students ask me this all the time. Well, can't they just refuse to enforce rules? Okay, there's 2 answers to that. Yes, if they're subtle. If they're subtle and they just say, oh, you know, we got scarce enforcement resources. And so the one inspector who likes to spend most of his time playing chess anyway just doesn't get around to, you go to court and say, I got scarce resources, I'm doing the best I can, okay, you're fine. Nobody. If you actually issue a rule or have anything formal in which you say, we're not going to enforce this rule, you're in trouble. So if he does it subtly, and I haven't seen very much he's ever done subtly. If he does it subtly, he can probably do it. If he does it with, here I am, I'm running the world, I'm doing it, he's in trouble in court.
This is great. Professor Dick Pierce teaching subtlety to Donald Trump. Bill, you wanted to jump in really quick, and then we'll go to the next question.
Yeah, no, I was just saying interpretive rules, they can be very disruptive. The CFPB tried to put out an interpretive rule, completely reimagining what the Electronic Transfer Funds Act, how it applied and who needed to comply with it. And they just said, oh, well, we can do this. We're just reinterpreting one word in this statute. And presto changeo, we're expanding who this applies to. And so I think efforts like that are easily challengeable for the purpose of you need to go through notice and comment. Working at the DOJ, prosecutorial discretion, I think what's happening is it always is applied, but we just like the people wielding discretion to be a lot closer to the action, even though they're sort of like the little mini instantiation of the president for the purposes of enforcing the law. Like, we don't like it when the president's doing it. We're okay with the person that you don't see doing it. Maybe that's changing.
Next question.
Yeah, I like that last point about subtlety. I wonder how that could be applied to what Biden did with the southern border and the immigration laws. That's not my question, however, and my question is directed to whoever feels they can answer it. So in terms of what's actually going to happen with respect to deregulation from a public policy point of view, I'm interested in just the really big items. Now, one of them is the banking rules, which Scott Besson's talking about all the time. That's going to happen, and industry will provide all the data that anybody needs and all of the answers, and all you have to do is pick up the industry briefs in order to put that forward. But that also isn't my question. What I'm interested in is the problem that everybody left and right has been pointing to constantly, which is the inability of anything to get built in this country without a 10-year delay in permitting. And I have heard half a dozen panels at the Federalist Society talking about this, how outrageous it is. And it's almost like we can't get out of our own way. Trump has made a point of it with respect to his various tariff. Like, if you come in here and build, we're going to make clear all the way. Do you think it could happen?
Let's let the panel. Bridget, I'm going to let you have the first bite at the permitting apple. Go ahead.
I think we could see some deregulation in the direction of permitting. That would seem entirely consistent with this administration's agenda. So end of comment.
Anybody have anything to add on that?
Yeah, I actually, a couple of views on this. First of all, I do think there's a terrible problem. I mean, if we fought World War II to III tomorrow, we'd have a real problem. We quadrupled aluminum smelting capacity in 2 years in the early 40s. It would take us 200 years today. And the permitting is an enormous problem. I think a hell of a lot of it is at the state and local level. And while some of the environmental advocacy groups are no longer opposed to it because it's now blocking a lot of the renewable energy projects, a lot of the incumbents in the electricity industry are very much in favor of permitting obstacles because they don't want to see those new sources coming online. And so what you find in many cases is it's citizens against this transmission line that are blocking it in every county and state that would have to go through, but all the funding is coming from the owners of the fossil fuel plants. So there's been a change in the direction that could help get us permitting reform, but there's also been a big change in the other direction that's now created a whole new crop of opponents who they never put their names out there. What they do is they put their dollars. When I was in practice, I used to do this for clients all the time. Citizens to do this, that, and the other, and it's actually my clients who are providing all the cash, and that's what's happening to a lot of the efforts, unsuccessful efforts for permitting reform.
I will say at the very end of the Trump administration, I was at DOJ. We were actually working on reform for this with like ENRD at DOJ and closely with the EPA and OMB. We're trying to gut the procedural loopholes that drag stuff out. I actually don't know what happened to that. And if they're going to do it again, because they need to do it again or do it more durably, I guarantee you they're starting now, and they're not going to wait till year 4.
Bridget, were you going to say one more thing?
I was just going to say, I mean, the ability, this is an example of an area where in order to write rules, you need the internal capacity to write the rules. And so, maybe there's a blueprint from term 1 that makes it easier on this
And they have
score.
ChatGPT. You just put it in.
Yeah, but the reasoning element of this and the ability to actually write the rules to address, say, modern case law on like low propriety and other things. So I guess like gutting your internal capacity, it presents an immediate roadblock to actually being able to draft the things that you want to do to change policy. And when I say gut your internal capacity, I mean indiscriminate layoffs, RIFs, and people basically having retirement and early resignation laid out to them as a pathway in order to avoid the deeply demoralizing conditions that they're in at the moment.
I'll just add, by the way, on permitting, it'll be interesting to see how the Supreme Court handles that pending infrastructure case, what's it called, 7 Counties Infrastructure Coalition, the Utah Railroad case. Let's try to get two more questions in. We'll take both of them at once, here and then here, and then we'll see if we have any time left.
Hello, this question's for any of the panel members. So I was a senior financial economist for a financial regulator doing their cost-benefit analysis and other regulatory analysis. Now I'm retired and I'm consultant for the other side of the table, the regulated entities. And I currently have 2 lawsuits to set aside ATF regulations because of their deficient regulatory analysis. And one judge denied a preliminary injunction that basically ignored all of the deficiencies. So I was wondering if any of you are familiar with any authorities holding the government accountable to EO 12866, 13563, and OMB Circular A4.
I see heads down. Let's just answer that, and then we'll move on to
There
the
are
next
no
question.
cases. There cannot be. Those are not judicially enforceable.
Okay.
They are enforceable basically by the president. They cannot be enforced by a court.
Great. Brent?
Brent Scorup, Cato Institute. So telecom law is a great deregulatory story. Telecom law is also filled with a lot of quirks and legislative experiments. One of those would be the FCC's forbearance authority, which seems somewhat unique to me in that the FCC can forbear not just from regulation. Actually, it's mandatory they forbear from core provisions of law if certain conditions are met, not just regulations, but also statutes, essentially giving the FCC the ability to forbear from entire statutes. And not only that, a private party can petition for forbearance, and if the FCC doesn't act on that within a year, there's forbearance. So it's a very powerful deregulatory law. I think it's survived in part. Progressives probably wouldn't want to challenge it and revive the non-delegation doctrine, and conservatives favor the deregulatory purpose. But are there analogies? Has Congress created a cheat code for deregulation, and are there analogies or analogous statutes in other industries?
Remember the Bush era immigration statute was the Real ID Act that had some waivers of environmental permitting requirements. Clean Air Act has a provision that famously waives the preemptive effect of EPA regulations when sort of California gets approval for new auto regs. Any other examples?
Well, that one, I think, is coming before the Supreme Court soon, isn't it?
Everything's coming
The
before the Supreme
California
Court
waiver.
soon.
Yeah, probably. But I do think that California waiver one is I think they may have already granted suit on that.
Okay.
That's being CRA.
CRA,
Is it
yeah.
Oh, it's
also
being
going to the court?
CRA,
Yeah.
I'm sorry,
Yeah,
yeah.
which
Oh, that's
meaning it
right, the
doesn't
big
get to the
issue
court.
is whether it counts as a rule, whether a waiver qualifies as a rule under the CRA,
Yeah.
and that's
And-
gonna be
And Congress
interesting.
is, apparently their view is, it doesn't matter, because if we say it does, then it does, and I think they're right about, well, Todd Gaziano wrote that we could get him, but that's what Todd told me over the weekend. It's true.
You know, Dick alludes to this, but to put a fine point on it, the funny thing about enforcement discretion with agencies is basically an agency might succeed in under-enforcing a regulation, but only if the agency doesn't go around taking too much credit for it. It's like the great paradox of it. It's the thing you'd want to take credit for, but if you do, the jig is up. Next question.
Hi, my name's Jacob James Rich. I'm an analyst at Reason Foundation and a PhD student at the Case Western Reserve University School of Medicine. That name has too many words. Professor Pierce, did I hear you mention wages in White Lion?
Yeah,
Yeah. I always think about objective ways, like whether courts can evaluate objective facts in data. So could you kind of elaborate on the purpose of cost-benefit analysis in those types of cases? Because I think about the FDA, Center for Tobacco Products, doing regulation for the protection of public health. And if I see what they're doing, I think it's very clear to objectively show what they're doing is not protecting public health. These various measures of public health that are quantifiable are getting worse because of the regulations, and I think they should be challengeable that way. But they have a lot of deference to figure out what that term actually means, right?
yeah, now, it's a really interesting case to use to try and work through all of those problems, because to start with, cost-benefit analysis is required only in the case of rules, and in that case, the agency had the option of using rulemaking, but chose instead to use a series of adjudications. The Supreme Court said that was fine, applying a doctrine that's been around for about 45 years now, and saying an agency has a choice, unless Congress has directed them to use rulemaking, to use either rulemaking or adjudication. And they chose adjudication. They reached the same result in each of the cases they adjudicated, but it was not through the use of rulemaking, so cost-benefit had no analysis, no role to play. Now, the statute, in a sense, requires cost-benefit analysis, but not in a quantitative sense. And the courts tend to stay out of that. I mean, the judges and numbers don't usually mix very well. So what the statute says is, would the benefits of flavored, what are they called now?
ends or e-cigarettes?
Yeah.
E-cigarettes, yeah.
Would the benefits exceed the cost in the form of inducing more kids to smoke? And the agency concluded that the proponents actually the applicants had the burden of proof. And the agency concluded they had not carried their burden of proving that the benefits of providing flavored joints would be outweigh the detriments, and Justice Alito upheld the agency.
Great, Dick. Well, and speaking of numbers, it's 4:21. We're out of time. We're past time. I'm sorry we didn't get to the remaining questions. Sorry, Ramon. But just a quick reminder, folks, at 4:30, the next session will be the closing address here in the Grand Ballroom with the Justice Department's Assistant Attorney General for Civil Rights, Harmeet Dillon. But before then, please join me in thanking our panelists.